Thank you. First of all, let me commend the CJ for this approach. But my difficulty is the personalization of the practice direction guidelines. Because you see, we are all trained. We know that practice directions are issued by the Supreme Court.
They have been issued by the CJ?
No, they are issued by the Supreme Court. We call the Supreme Court practice directions, not Chief Justice's practice directions. You can cross-check.
The practice directions after the Bafuboni case,
yes,
for disclosures, yes, in criminal trials,
yes,
were issued under the hand of the CJ.
They are issued in the name of the Supreme Court. Okay, so, but the attempt, because I'm saying, so are we going to cite it as CJ Tokonu's practice directions?
No, the directions tell you how they should be cited, each one of them. If it has to be court-connected ADR, if it has to be pre-trial, yes, for commercial cases, yes, and all, it tells you how to cite them. And so, the individual's name doesn't, yes, come in.
Sure. Okay, so, well, then I'm guided.
Right.
Okay, so I'm happy about the practice directions because, you see, it goes to fill the small lacunas that we have in our rules of court procedural laws and all that. Then they also have a force of law. You know what I mean. So these directions will help. But you see, I am hearing the CJ speak highfalutin sounding words in terms of policy approach and all. And I'm gauging that with a conduct. I went to court. Mm-hmm. I filed a matter and followed it up with an application for interlocutory injunction. The registrar of the courts, and I have another problem with that arrangement. How come we have a circuit court appointed as a registrar of the Supreme Court? How is that possible?
A circuit court judge?
Yes.
What's wrong with it?
There's everything wrong with that. Because how are you going to evaluate the work of the circuit court judge as a registrar? Because the work of a registrar...
The judicial secretary is a judge, is that not so?
She is.
Correct.
She is.
You haven't found anything wrong with that?
So I speak of approach. Because the judicial secretary, she has a constitutional role. Mm. If the judiciary decides that a trained judge should occupy that office, so be it. But the registrar of a court within the Courts Act doesn't function as a judge. So if you have a circuit court judge who is supposed to be delivering judgments at the circuit level, then she will be evaluated for purposes of elevation. Who has abandoned that?
Okay, so she doesn't leave the job as circuit court judge. So it's like acting...
Who is complaining? Who is complaining?
I am complaining.
No, but they are the ones who have employed... The judicial service has employed the circuit court judge.
No, something. We understand why...
I think...
And if the person is capable of playing a dual role...
Is she playing a dual role? Is she sitting as a circuit judge and at the same time functioning as a registrar of the Supreme Court?
It could be secondment of sorts.
That is not the case. No, that is
to
not
be
the case.
Registrar.
Look, if we speak of reforms, let's speak of reforms properly. Mm. And I have a problem that we have a judge who is acting as a registrar of a court. So I filed a process. You issue a notice to me that a date will be fixed 14 days after the respondents are served with the processes. Then the next day you decide to serve a process, not on me, not on my lawyer, or my lawyer's firm. The matter is determined based on that. Then a couple of days later, you come and tell me that we want to follow procedure, we want to... So I am gauging her words with her conduct. They are not in sync.
Well, there's actually, in the compendium, there's actually administrative guidelines on using the Supreme Court registry.
Certainly. It is coming after what I've suffered in the court. That's the point I'm making.
That you didn't know does not mean that this had not been in place.
How is that in place?
If it were not in place, a circuit court judge would not be acting as a registrar.
But I'm saying that which law supports that?
Which law does not support that?
You can't appoint a judge as a registrar of a court. That is my point.
Okay.
Because a judge is a juristic officer. Their duties under law is separate and their privileges.
Okay, so let's not reduce it to this. Let's look at the general.
It's a very material point that the privileges of a judge who sits over cases is different from the privileges and the conditions of service of a registrar of a court. And their functions are not coterminous at all. So that confusion must be cleared. 2, I am saying that these lofty ideas are good. She speaks of budget and all. But in streamlining the judiciary, I think that one of the tasks that is hurting the judiciary is not even about inefficiency. I haven't heard that our judges are inefficient. It is rather the workload. Having so much workload does not go to inefficiency. It's different. You can be efficient and delivering on your mandate with speed and all. But when the person who is assigning the cases is not taking into consideration the number of cases before you and keeps piling them, that cannot go to inefficiency. That cannot go to efficiency. So we should be talking about the fact that we've automated allocation of cases, at least in the High Court, in the Commercial Court, General Jurisdiction and all those divisions. I know that the assignment of cases are automated. Under the e-justice system, I don't know, suddenly it's now digitalization, but the e-justice has been launched by government long ago under Professor Mills. In fact, when the modern court complex was built, that was when the e-justice system was launched. In fact, it had been launched much earlier, but it was piloted. But it was officially launched. So we ought to continue with that and streamline the assignment of cases to courts, that you don't overburden a judge who has so many cases or so many parties pending before him with new cases. That is why we are opening new high courts, new circuit courts, and all. That's why we are appointing new high court judges, appointing new circuit court judges, new magistrates. It is to offload the burden on the existing ones.
And also for places where there's no access.
Yes.
There are no courts.
Then
or the
I was
distance
hoping that there would have been a report evaluating the impact of the e-justice program.
That's very important.
All right? So that we know that since the introduction of the e-justice system about 12 years ago, this has been the impact. And that when these policies are further introduced, it will help to improve the justice delivery system in A, B, C, D manner. We haven't seen that report. So when we have a court administrator for the modern...
Properly so called, the e-justice was not introduced 12 years ago.
Why?
It wasn't. It's not 12 years ago.
When was it?
12 years ago, we were doing all the manual things.
No. It was piloted.
It was piloted.
We were in practice.
Where? Is it in the commercial court or the fast track high court?
It was piloted in the fast track high court.
Right.
Then it was launched by Professor Mills when in fact, he had then died.
But properly speaking, the e-justice is it's less than 5 years. About 5 years or so old.
Maybe earlier.
No, it's not. No, much earlier than that.
I attended one of the training when we're all being trained as lawyers to know how to file your...
Including the bar took a bit of time.
Yeah.
The e-justice, when practice, filing of process,
Justice Wood,
and all.
Yes,
the CJ Wood, she launched it.
Okay.
Under a World Bank facility.
Then my memory is just...
No, you are at the bar now.
Okay. So she says she deeply craves, along with all their well-wishers, to change the tag of corruption, ineptitude, and inefficiency around the judiciary and judicial service of Ghana. And she says they cannot do this without the support and attention of all stakeholders.
Yes.
A number of things are being put in place.
Yes, I agree.
Including the practice directions, guidance, about 12 different ones.
Yes.
We know that they may not be binding, but you can see they are made on the basis of law, judicial decisions, and they will help to fast track the court's process, correct?
In fact, if you read shone and shone in the UK Supreme Court recently, it has a force of law. But if you don't comply...
They do, right?
Yes. If you don't comply with the practice directions, a procedure pursued or a decision pursued can be struck down on grounds
Because
of
you didn't do your
non-compliance.
part.
Because, exactly.
Because the practice direction aligns with law anyway.
Exactly.
Right.
Exactly. In fact, it's like a subsidiary legislation. But these are judgment laws, so they call it judgment laws.
Right.
And they are force of law because they emanate from case law in terms of case management. These are all rooted in the doctrine of case management, which CJ correctly quoted. That is the Lancaster House principles and all. So I agree that we need to do this, but we are also gauging it with conduct. We also have a problem with empaneling the courts. Look, I have a matter before the Supreme Court, the First Lady's case. It's nearly 4 years, 2021 to now. The issue is about empaneling. The panel, one panel member is unwell, one is traveled. So now, on the 18th of March, I've been given another hearing notice to appear on the 24th. I pray that day, the judgment will be delivered. So if you have constitutional matters such as that deserves expeditious attention, and it delays this inordinately long, it's a problem.
All right.
Look at them.
So definitely you will be happy about the practice direction that is intended to ensure expeditious trials.
Of course.
Right.
Of course.